What if a short vacation could jeopardize your future in America? In 2025, thousands of U.S. green card holders are learning that even lawful travel can trigger new scrutiny at the border. The laws haven't changed, but the enforcement has. Today on Global Lens, we uncover 7 new enforcement rules now reshaping life for permanent residents. You'll learn how short trips abroad, tax filings, or even your home address can raise red flags, and what you can do to protect your status. Stay to the end to understand how these changes could affect your path to U.S. citizenship. And if you find value in factual global updates like this, don't forget to subscribe and turn on notifications. Chapter 1. The Quiet Shift at America's Borders. For decades, green card holders, officially known as lawful permanent residents, have been free to travel outside the United States as long as they didn't remain abroad for extended periods. 6 months was considered safe. A year or more often triggered questions. But in 2024, something changed. Not in Congress or the Federal Register, but inside U.S. Customs and Border Protection. CBP began analyzing travel data more deeply, using passenger manifests, passport scans, and automated risk modeling to identify patterns of frequent absence. Officers were instructed to evaluate not only how long someone stayed abroad, but how often they left. According to immigration attorneys in Los Angeles, New York, and Houston, multiple clients who traveled abroad several times a year, even for short visits, were questioned, flagged, or referred to secondary inspection. No statute changed, but the standard for suspicion did. This new focus reflects a policy goal, verifying that green card holders actually reside in the United States rather than treating permanent residence as a convenience card for international living. Chapter 2. Rule 1. Frequency over duration. Under this new enforcement mindset, frequent short trips can now look worse than one long absence. In past years, a single 4-month stay abroad might have drawn no attention. Today, 4 separate 3-week trips in the same year might. CBP officers reviewing your travel record can conclude that your center of life, your home, family, or work, appears to be outside the U.S. It's a subtle but powerful change. The Department of Homeland Security now treats travel frequency as an indicator of intent, and intent is the legal heart of permanent residence. If your pattern looks more like that of an international commuter than a domestic resident, you may face questions such as, where do you actually live? Where is your job based? Do you pay U.S. taxes as a resident? For most travelers, the process ends there. But if answers are inconsistent or documents don't match, the officer can mark the file for future inspection, meaning every future trip will face added scrutiny. Immigration lawyers describe this as residency by algorithm. It's not new law. It's a change in interpretation that can have real consequences. Chapter 3. Rule 2. The re-entry permit is no longer a guarantee. For years, a re-entry permit functioned as a safety net, allowing green card holders to remain abroad for up to 2 years without losing status. That protection is now conditional. CBP officers at ports of entry have broader discretion to deny entry or refer cases to immigration court if they believe the permit is being used to mask foreign residents. In 2024, immigration lawyers reported hundreds of cases where travelers with valid re-entry permits were interrogated or issued notices to appear. The official explanation: the permit is permission to apply for entry, not a guarantee of admission. If your ties, home, taxes, or job appear based abroad, the permit can be challenged. This shift reflects the government's effort to curb what it calls green card misuse, referring to individuals who live overseas but continue to collect U.S. benefits or claim residency advantages. The message from officials is blunt. The green card is proof of a life in America, not a travel document of convenience. Chapter 4. Rule 3. Proving your life in the U.S. Many permanent residents now find that returning home feels like an audit. At major airports, CBP officers increasingly ask for proof of U.S. ties, not just a passport and green card. They may request pay stubs, lease agreements, mortgage statements, or recent utility bills. Some travelers even carry folders of documentation to avoid delays. It's not a legal requirement, but in practice, lack of proof can lead to hours in secondary inspection. In serious cases, officers issue a notice to appear in immigration court, arguing that the traveler has abandoned residence. Civil rights groups have criticized this approach as proof-based profiling, warning that it disadvantages retirees, students, and caregivers who lack conventional employment documents. Still, Government officials defend the policy as essential for preventing residency fraud. In their view, the burden now lies with the traveler to demonstrate continuous connection to the United States. Chapter 5. Rule 4. Emergency travel still counts. For many immigrants, family obligations abroad are unavoidable. Caring for a sick parent, attending funerals, or handling property issues. In the past, officers often granted leniency for humanitarian reasons. Under the new enforcement trend, even genuine emergencies can count against you if they appear to break a pattern of U.S. residence. CBP officers are trained to examine intent objectively, not emotionally. A trip may be entirely reasonable in context, but still raise concerns if it interrupts steady employment or leaves no evidence of an ongoing U.S. life. Immigration lawyers say this shift has created a painful dilemma for many families. Choose between personal duty and immigration security. Officials counter that leniency was abused. Some travelers repeatedly cited family emergencies while living abroad long-term. The result is a uniform standard that treats nearly all extended absences as potential red flags, regardless of motive. Chapter 6. Rule 5. Taxes reveal your true residency. One of the most overlooked risk factors lies not in travel, but in tax filings. U.S. immigration law expects green card holders to file taxes as residents. Filing as a non-resident alien or claiming foreign tax residency can be interpreted as intent to abandon U.S. residence. Since 2024, data sharing between the Internal Revenue Service and the Department of Homeland Security has intensified. When a green card holder applies for naturalization, USCIS cross-checks tax records. If the applicant filed as a non-resident or used a foreign address, the case may be delayed or denied. Law firms in California and New Jersey report dozens of clients whose citizenship applications were suspended for this reason. The principle is simple. Your tax status reflects where you claim to live. If that conflicts with your immigration status, officials may treat it as evidence that your intent to reside no longer exists. Attorneys warn that many tax preparers are unaware of these consequences, inadvertently setting up their clients for years of complications. Chapter 7. Rule 6. Officer discretion has expanded. Perhaps the most unpredictable change is the growing discretion of border officers. There is no single formula defining what counts as abandoning residence. Each officer has authority to assess your intent based on the total picture: your travel record, your answers, your documents, even your demeanor. Two travelers with identical histories can face very different outcomes depending on the judgment of the officer on duty. That's why some lawyers now call the process green card roulette. Once an officer doubts your ties to the U.S., the consequences cascade. Your record may be marked for future screening, your re-entry could be delayed, and your case might even be referred to immigration court. There's no appeal at the airport. The burden of proof falls entirely on the traveler. DHS officials defend this flexibility, saying it allows agents to detect fraud and misuse quickly. But critics argue that unchecked discretion risks inconsistency, bias, and unequal treatment, particularly for older immigrants or those with limited English proficiency. Chapter 8. Rule 7. The hidden trap. Before citizenship, the final and most devastating issue arises during naturalization. To become a U.S. citizen, an applicant must prove continuous residence and physical presence in the United States. Even a single trip lasting over 6 months, or a pattern of frequent shorter trips, can reset that clock. USCIS officers have become increasingly strict in reviewing travel during the 12 months before an interview. Applicants who took one long trip or many short ones are sometimes told they broke continuity and must wait 4 more years to reapply. What's worse, a denied citizenship application can trigger review of the green card itself. If the officer concludes the applicant did not intend to live permanently in the U.S., they can refer the case for revocation proceedings. In practice, that means a single ill-timed trip, even one done legally, can delay or jeopardize a person's future entirely. Immigration lawyers advise avoiding any long absence in the year before applying for citizenship, no matter how justified. Chapter 9. What's really going on? Behind these 7 enforcement rules lies a broader political and administrative goal. The United States grants roughly 500,000 new green cards each year, but government data show that thousands of holders live mostly abroad while maintaining U.S. benefits. In 2023 and 2024, DHS launched internal reviews aimed at tightening definitions of permanent residence. Rather than pass new laws, which require congressional approval, agencies have adopted stricter interpretations of existing authority. They use digital travel records, IRS data, and address databases to flag potential misuse automatically. The system increasingly relies on algorithms rather than interviews, creating new risks for people who travel frequently for work, caregiving, or business. Critics call this a technological overreach that punishes legitimate global mobility. Supporters say it ensures fairness by applying the same standard to everyone. Live where your residency says you live. Either way, the result is the same. More questions, more paperwork, and more uncertainty at the border. Chapter 10. How green card holders can stay safe. Legal experts emphasize preparation, not panic. First, maintain clear evidence of your life in the United States. Lease or mortgage records, utility bills, tax filings, pay stubs, and U.S. bank accounts. Second, if travel is unavoidable, document your reasons, medical letters, employer memos, or family records. Third, never file taxes as a non-resident unless advised by a qualified attorney, and always keep copies of filings. Fourth, avoid long absences in the year before applying for citizenship. And finally, if you're questioned or receive a notice to appear, consult an immigration attorney immediately rather than trying to explain the case yourself. None of these steps are guarantees, but they help prove continuous ties and intent to reside, the two factors that matter most under current enforcement. Chapter 11. The Human Impact. Beyond the paperwork and legal jargon lies a deep human toll. Families are divided across continents. Parents miss milestones with their children. Elderly immigrants are afraid to leave the country, even for funerals, fearing they won't be allowed back. Attorneys say clients arrive at their offices carrying boxes of utility bills and photographs, evidence not of guilt, but of belonging. Many feel trapped between two worlds, rooted in America, yet treated with suspicion each time they return. Advocacy groups have urged Congress to clarify what intent to reside means in the digital age, where remote work and dual households are common. So far, no legislative reform has advanced. Until then, interpretation remains in the hands of officers and algorithms. Chapter 12. What it means for the future. The current crackdown may mark a turning point in U.S. immigration policy. Rather than tightening laws, agencies are tightening interpretation, a strategy that requires no public debate. That approach is likely to expand, especially as data analytics allow authorities to track travel and tax behavior in real time. For green card holders, the implications are clear. Permanent residents must look permanent, both on paper and in daily life. In practice, the boundary between frequent traveler and non-resident is getting smaller each year. As global mobility increases, so does the risk that legitimate movement will be mistaken for abandonment. Understanding the rules and the mindset behind them is now essential for anyone who hopes to turn a green card into citizenship. The message for 2025 is simple but sobering. The United States hasn't changed its immigration laws, but it has changed how it enforces them. For green card holders, intent now matters more than ever, and even short trips can raise red flags. Staying informed and maintaining clear ties to America are the best defenses in this new era of scrutiny. If you found this breakdown useful, make sure to subscribe to Global Lens for more factual, policy-based insights from around the world. Your understanding of global rules today can shape your freedom to move tomorrow.